Final witness on this panel is Judge Nathaniel Jones. Had served as Executive Director of the Fair Employment Practice Commission, was an Assistant U.S. Attorney for the Northern District of Ohio, directed NAACP litigation as General Counsel for 10 years, a graduate of Youngstown State University, both bachelor's and law degrees, and served on the Court of Appeals for the Sixth Circuit, and is now retired. Judge Jones, thank you for coming in today, and we look forward to your testimony.
Thank you, Mr. Chairman and Senator Lay, and esteemed members of the committee. I am honored to have this opportunity to appear as a witness today to, I hope, assist you to more effectively evaluate the fitness of John G. Roberts to be confirmed as Chief Justice of the United States by providing an historical perspective. Mr. Chairman, I ask that my full statement be introduced in the record.
Without objection, Judge Jones, it will be a part of the record.
Thank you. My acceptance of your invitation to offer testimony is prompted by my conscience and is driven by a profound obligation to introduce into the record an historical perspective, and in doing so I join with my colleague John Lewis, whose life is a personification of courage. And I wish to add to his description of the struggle for civil remedies and civil rights remedies. You are confronted here, I suggest, with a serious constitutional and moral responsibility. You are considering, under the Constitution's advice and consent clause, the fitness of a Supreme Court nominee who has, in the past, argued against the use of federal power to eradicate the vestiges of slavery and the badges of servitude. This record triggers serious questions and a vigorous inquiry into the whys. So much of the nominee's advocacy as a government lawyer and counselor was in the direction of against the implementation of civil rights remedies. There's been a lack of balance. While I appear in my own right, more importantly, I am invoking the voices of distinguished legal giants whose voices have been stilled by time. Dean Charles Hamilton Houston, Justice Thurgood Marshall, Judge William H. Hastie, Clarence Mitchell, James A. Nabritt, Judge Spotswood Robinson, Judge A. Leon Higginbotham, and many others who have my, and I trust your, deep and enduring respect. These individuals believed in the Constitution, and they hoped that government would step up and protect the rights of the minorities and the persons who were victims of majoritarian excesses. They fashioned a strategy for using the law and the courts to attack racial segregation. They set the stage for the development of remedies to remove the stain of racial segregation that law and the courts imposed upon this land. You may ask why I invoke their names and speak in the voice of these towering legal giants and hold up the contributions they made to the advancement of civil rights jurisprudence. My reason is twofold. First, my professional and personal experiences qualify me to do so. Second, since he was nominated by the President, serious questions have been raised concerning Judge Roberts' views about the relevance and legality of remedies aimed at ending racial discrimination. Unfortunately, few Americans know or have focused on or are familiar with the history of the myriad ways the positive law and legislatures and courts reinforced and perpetuated racial discrimination in America. It is up to this committee, therefore, to assure that at the very least, the next Chief Justice of the United States understands that history, and most importantly, why remedial action was and continues to be necessary. Those courageous souls who laid the foundation for overturning decades of legally enforced racial segregation are calling out to you, and I echo their voices to respect their labors and heed their lessons. One's fitness to be the Chief Justice transcends stellar economic and academic achievements and acknowledged professional competence. The nominee's views and his documented activist attempts to thwart the federal court's efforts to dismantle segregation schemes the courts themselves permitted to be erected and sustained bring into play something much more fundamental than technical skills. The critical question before you is one of values, not competence. To understand why this is true, one need only consider the most wretched decision the Supreme Court ever handed down in a case of human rights, Dred Scott versus Sanford. The author of that decision, Chief Justice Roger Taney, was undoubtedly highly qualified from a technical and professional standpoint. Yet faced with the fundamental question of whether a former slave had standing to sue to retain his newly acquired free status, Justice Taney wrote that black people were not persons within the meaning of the framers of the Constitution. Similarly, Henry Billings Brown, the author of the 1896 Plessy versus Ferguson decision, had impressive professional credentials and academic as well. He was a graduate of both Harvard and Yale, and his prior judicial experience, which was on the Sixth Circuit Court of Appeals, but he lacked the values that sensitized him to understand why the 13th, 14th, 15th Amendments had to become a part of the Constitution. On the other hand, it was Justice John Marshall Harlan, the lone dissenter, a graduate of a much smaller law school, the son of slave owners, who gave us the final word. And his word is his word that has rung through the years. Gentlemen and lady, I would conclude with this observation. Abraham Lincoln stated in his famous speech in 1862 to the Congress that, fellow citizens, we cannot escape history. And it was George Santayana who said, those who cannot remember the past are condemned to repeat it. But given the nature of the exchanges that I have observed taking place this week in connection with the hearings, I would leave with you the words of Dr. Martin Luther King. He asked and answered these questions. Cowardice asked the question, is it safe? Expediency asks the question, is it politic? Vanity asks the question, is it popular? But conscience must ask the question, is it right? I leave you with those challenges.
Thank you very much, Judge Jones. Our practice in the committee is to have 5-minute rounds. In setting the witness list, we had many requests. And we have honored as many as we could with some 30 witnesses equally divided between Democrats and Republicans. Usually there's a tilt for the majority, but my decision was to divide them equally. We have a very long road ahead of us. This is the second panel on 6th, and it is my hope that the questions will be abbreviated. We wanted to see you and hear you and have your statements and have your views and look you in the eye. I personally will have just a few questions which I will want to ask. And let me start, Congressman Lewis, with you, with great appreciation for what you have done. The Voting Rights Act, which we labored through in 1982, and I was there in Senator Dole's office, and Senator Kennedy was deeply involved, and so was Senator Leahy, and so many of us were, to get the effects test instead of the intent test so that we have some realistic enforcement of civil rights. Senator Kennedy and I have already conferred. He came to me, said, let's renew the bill this year, the act this year if we can. It's the 40th year anniversary, and we have a jammed agenda. We're going to try to do that, but it will be renewed. It doesn't expire until '07. I'm very much with you on the objectives and what we have to do. The memoranda which are referred to, and there are quite a number of them, go back to Judge Roberts' days as a young lawyer, and he has testified that he was representing a client, and we had real battles with the Reagan administration. There's no doubt about that. And I was involved in them, notwithstanding the fact that it was my party. But Congressman Lewis, I would like your views as to how you regarded what Judge Roberts said in explaining his views at the time, or what the memoranda said, which he said were not necessarily his views, and you have to evaluate that, contrasted with very close questioning by Senator Kennedy and others where he did not raise objections or said he did not have an agenda to turn back the clock.
Well, it's my view, Senator, that, Chairman, that the judge was on the wrong side of history. He was on the wrong side of the voting rights side, not just the letter, but also the spirit of the act. It is very hard and very difficult, almost impossible to prove intent. You don't have, I think Vernon Jordan, the former head of the Urban League, said on one occasion that you won't have people in the American South, in the 11 southern states of the old Confederacy, from Virginia to Texas, putting up signs saying we're going to discriminate. We're going to keep black people from getting elected. They're not going to do that. I was young too a few years ago, 24, 25, but I tried to do the right thing. I got in the way. And I think Judge Roberts, as a young attorney in the administration of President Reagan and others, failed to go with his gut. Maybe. Did he go with his gut? Did he go with his heart? Or was just his views? You don't come back years later and say, oh no, this was not my view. Sometimes you have to fight. Sometimes you have to get in the way. If you can't get in the way when you're 25 or 30, you're not going to get in the way when you're 50.
Thank you, Congressman Lewis. I just have a minute 40 left, and I want to give Governor Thornburg an opportunity to comment. Based on your knowledge of Judge Roberts, and you worked with him at a time when he was young, do you think that those memoranda reflected his own views as to civil rights, or what do your insights and your knowledge of Judge Roberts tell you as to what we might expect of him as Chief Justice, if confirmed, on these issues?
Let me say just three things in response to that, Senator. I have never seen any evidence of any hostility to civil rights on the part of Judge Roberts during my professional and personal association with him, which goes back some 15 years. Secondly, I think it is important, and Justice Ginsburg was quite definite in this in her appearance at the time of her nomination, to separate out the views that are expressed as an advocate for a client and the views that might obtain if the individual were speaking for him or herself. And thirdly, I don't think any of us could stand, perhaps my friend John Lewis could because of his distinguished career, but I don't think any of us could stand a complete and thorough rummaging through the views we expressed when we were 20 or 25 years old. I shudder to think that some of the things that I had in my craw at the time would stand the test today. But most importantly, I think is my conclusion that on the basis of my personal knowledge of Judge Roberts, that there's no hostility there to civil rights. There's a veneration of the rule of law, and to the extent that the rule of law permits, it seems to me that he would be a strong supporter of equal rights and equal treatment and equal justice for all under the law.
Thank you, Governor Thornburg. This is a very, very distinguished panel. We could hear a great deal more, but my time is up, and I have to set the lead on observing the time. Senator Leahy, do you care to question?
Just a comment, and of course, Governor Thornburg is a friend of all of ours. We've worked with him during his time as the Attorney General, and when you mentioned Justice Ginsburg, just so the record is clear, her appearance here is a lot different. She answered questions from numerous senators on race discrimination and affirmative action. Several other senators, she answered questions on gender discrimination. Several other senators, she answered questions of reproductive rights. From several other senators, she answered questions on death penalty. And then First Amendment, freedom of speech, religion clause of the First Amendment, separation of powers, unenumerated rights, 14th Amendment, role of the court, deference to Congress, and then had 3 or 4 that she didn't answer, but she answered specifically, but both Republicans and Democrats, very intensive. I only mention it because there seems to be some view that when Judge Roberts took, I think, too much to heart the recommendation made by some of the senators here not to answer questions, he took it too much to heart and did not answer those questions. When my friend John Lewis talks about time to get in the way, he knows of which he speaks. He nearly died doing that. But he's doing it for the right cause. The cause is civil rights. And I think every African American and every white American and every brown American, everybody else, all Americans, have to thank you for what you did. I'll yield back my time.
Thank you, Senator Lay. Anybody on the other side of the aisle want to say
Could I
anything?
have one thought, Chairman, just real quickly, if I could? And I want to welcome the panel, and particularly my friend John Lewis. We worked a lot on the African American Museum of History and Culture that's going to be here in Washington, D.C. Sometime soon. We got that passed through. Judge Jones, if I could just ask you a real brief question on this, because I hear your concerns and I hear the thoughts, and I respect the thought that you're putting forward here. Judge Roberts asked, when people asked him, I think Senator Durbin asked him, how do we know what kind of judge you're going to be on some of these issues? Obviously, you got a great head, but I want to look at your heart, and it's hard to see a man's heart. And Judge Roberts' response said, well, look at how I've ruled on the cases thus far, which there are not a lot of. I think 52 cases thus far, but it does have one, Washington Metropolitan Transit Authority, where he ruled against the D.C. government's claim of sovereign immunity and in favor of a workers' disability discrimination lawsuit. That's kind of thin, but well, we only have 52 cases, and that one's there. And then he also talked about his dedication to rule of law, and that's really what drew him into the law. And if he is sufficiently dedicated to that rule of law, given the laws now that we have on books, to work to protect civil rights and a number of other issues, shouldn't that give some solace that if his heart is right on defending the rule of law, given if we've gotten some of the laws better and right now, that he could be quite a good judge for civil rights cases?
Thank you for your question. And I would respond this way. I'll respond both as a former litigator, civil rights litigator, and as a judge. As a judge, we look at the record. The record that has been made here, the part of it that I have observed, shows an early disposition to take positions contrary to civil rights enforcement. The burden that is now imposed upon him and imposed upon this committee is to be satisfied that the presumption, or at least the inference, that one can draw from that prior record has been overcome, and that he doesn't share those views at this time. That's a burden and judgment this committee has to make. I would also point out that, if I may just be a little personal, at the time I left my job as a general counsel of NAACP, a position that I had occupied, which Thurgood Marshall also occupied, I had been involved in litigating major civil rights cases all across the country. I joined the court upon appointment by President Carter in 1979. At that time, we thought generally that certain civil rights principles were settled. We thought that the issue of school desegregation was settled in light of Chief Justice Berger's decision in Swan, in which he said that busing and transportation was an appropriate remedy when you had a finding of constitutional violations that rigged a school district. We thought the issue of affirmative action was settled with the Bakke case, with Justice Powell's plurality opinion, which he says you may take race into account. But we find that following that case, those cases which I thought were settled, I was then sitting as a judge on the Sixth Circuit Court of Appeals, and I was engaged in dealing with the first wave of attacks against school desegregation and against affirmative action. The challenges claiming preferential treatment, claiming forced busing, all of these buzzwords were coming at the court, and we were then faced with the decision, are these principles settled? And I've now learned that in the boiler room of the Reagan administration, stoking out and crafting a lot of the theories that were being used in the courts to attack these settled principles was the nominee. Now that raises a question for me and for you of this committee to decide whether, if one is a believer in the rule of law, why one would not accept Swan as settled law, would not accept Bakke as settled law, would not accept Weber as settled law, the whole body of jurisprudence that had been built up to reaffirm the value of remedial actions when it was clear that we had this vast history of racial discrimination in this country.
If I could, before my time runs out, just quickly say I appreciate the thought.
Would you make it quickly, Senator Brownback? We have to move on.
Okay. That I would note what Judge Roberts has ruled, what he has done as a judge, and I would hope people could look at that in the fair light of what it is and indicating his judicial temperament and nature. Thanks, Mr. Chairman.
Thank you very much, Senator Brownback. We're going to break for lunch at the conclusion of this panel. Senator Kennedy?
Thank you very much, Mr. I don't think any of us in the course of the time questioning Judge Roberts ever suggested that in any way he had any hostility on the issues of race. I really think the question was, does he get it? Does he get it? Just what the good judge has pointed out, the march towards progress that we have seen over the recent years. So I'd ask Mr. Henderson and then John Lewis, how about this argument? Well, he was just an attorney. He was just an attorney. He was speaking for an administration. He was just taking administration's position. So we shouldn't be too harsh on this. Sure, the administration was just wanted the reauthorization of the intent test. He was just following orders, so to speak, on this. And so why should we not assume that he gets it with regards to the issues of this nation's great challenge, the poison of discrimination that's there since the first days of it, and we've all seen, including in my own state of Massachusetts, the challenges that we have faced. What's your response to that?
Well, Senator, I certainly recognize a legitimate argument that an individual representing a client often projects the views that best suit the client. But I remind you, sir, that Judge Roberts never once distanced himself from positions articulated in many of the memoranda at issue in a way that would give comfort to the notion that he, in fact, had not internalized these views to reflect his own policies. Judge Roberts has a vision of judicial restraint, and he's articulated it himself, which is really a retreat from the role of the federal courts in protecting civil rights. And I guess, you know, from my view, this is really not an academic debate. It's very personal. I mean, I grew up right here in the nation's capital. I was 16 before formal segregation ended by law. I know what it's like to be on the politically disfavored side of the color line. And I know that the federal courts have played an important role in helping to ensure equal opportunity for all of American citizens, and we're not prepared to take that risk. I would simply say that even in today's society, Senator Brownback mentioned earlier, well, laws have changed, things have happened, they've improved. Certainly that is true. But in the words of William Faulkner, you know, the past is never dead. In fact, it's not even past. And just to confirm that point, I have a pending complaint right now before the Department of Justice for a case of public accommodation discrimination from a hotel in New Orleans over the 4th of July weekend in an area where I thought change had been made in a lasting way that would not have permitted that to happen. I know firsthand what that stigma is about, and I just reject that analysis.
Well,
Senator?
It is true that we did ask him. I asked him about whether any of these positions that he had taken at that time, whether he would reverse any of these, and we didn't hear a response from him that he might. Let me ask John Lewis to comment on that, and then also in your comment. I've got a minute and a half, John, so you know this business. So I hope you'll respond to the earlier question, wane. But I hope also, when Judge Roberts was asked about the intent test and the effects test, and he was asked also by members of the panel, well, if we had actually had the intent test, do you think we would have made the progress that we would have made with the effects test? And he said, I'm not so sure we might not have made the kind of progress on that. We know the earth-shattering progress that has been made with the election of officials locally, state, and at the federal level, and the progress that has been made with the effects test. I'm interested in someone who knows and believes that the Voting Rights Act is the key civil rights issue. What's your own view on this question? How could anyone view that if we had had the intent test, we'd be where we are today? Wouldn't we be a different land?
Well, I tell you, Senator, as someone who worked in the American South for several years, directed an organization called the Voter Education Project for 7 years, trying to get people registered, trying to get people to lose that sense of fear. People, I tell you, we wouldn't be where we are today. The American South would be different. The country would be different if we had relied on the intent test. I wouldn't be here as a member of Congress. And a lot of my colleagues in the House of Representatives, a lot of the elected officials all across the South, before the Voting Rights Act in 1965, there were less than 50 black elected officials in 11 southern states, from Virginia to Texas. Today, there are more than 9,000. We wouldn't have made it. There still will be people trying to get elected, and they wouldn't be elected. I don't buy this argument that he was just doing his job. He was just following the rule. By this time, you had the 64 Civil Rights Act, the 65 Voting Rights Act, the Fair Housing Act of 1968. By this time, there's someone in the administration, they should have a mindset. I think this says something about Judge Roberts' mindset. He didn't stand up and argue against this attitude. He didn't speak out. He didn't send a memo saying something different.
My time is up. Thank you.
Thank you very much, Senator Kennedy. Senator Durbin.
Thank you, Mr. Chairman. Thank you to the panel. Let me first thank my colleague, Senator Kennedy. I think that during the course of this inquiry of Judge Roberts, he has been laser focused on civil rights and the Voting Rights Act, and I think it's done a great service to the operation of the committee, and I hope that we all appreciate how much work went into it. But I do recall, Senator Kennedy, on the first day when you went into this, I made notes how Judge Roberts said repeatedly, that was 23 years ago. I was a staff lawyer at the Justice Department. That was the position for the administration I worked for. It was my job to articulate administration policy. We heard that consistently whenever we brought up these memos. And so I thought to myself, well, in fairness, if we're going to allow him to use that explanation, what does he feel today? What can he tell us today? I personally believe in redemption, in faith and politics. And I think, John Lewis, you have seen so many in the past who were on the wrong side of history on civil rights who realized it and conceded that and moved to a different position. During the course of this hearing, we asked Judge Roberts many questions. In fairness to him, one of the few direct questions he answered was when I asked him about Bob Jones University case. And he said, I disagreed with the position of the Reagan administration. I'm glad he said that. I wish he could have told us more. Then I tried in my last round of questioning to get down to a point of where would you draw the line as an advocate? Or there are some things you would not bring your legal skills to. You have spoken with pride of Romer versus Evans and the fact that you counseled gays and lesbians who were about to lose their rights in Colorado. And just a few hours ago, I asked him sitting at the same table, could you have taken the other position to restrict the rights? And he said yes. And so it comes down to a fundamental question. I don't think I understand if there is a clear, bright line in his mind when it comes to this issue of freedom and when it comes to this issue of liberty. And that troubles me because I think knowing that, I'd feel more confident that he could lead this court. But I'd like to ask you, John Lewis, on the issue of redemption. Do you feel that even if he was totally wrong 23 years ago or 24 years ago in his memos, that people can change?
Well, I think it's possible and it's conceivable, Senator, that people can change. But when you believe and feel and know from your experience, or maybe from the law, and from history that you've been wrong, you show some sign. And you're not afraid to talk about it. You're not afraid to go on the record. Judge Roberts has been afraid to show or demonstrate any signs that he's changed. I wonder whether it's part of his mindset.
Well, I think that's the point, and maybe Wade Henderson made the same point, that when Senator Kennedy went directly to the Voting Rights Act, much like Bob Jones University, he could have made it clear that that position was just wrong and that history had proven it wrong. And yet, for 2 successive days, it came up short. Wade Henderson, you've made that point in what you had to say here, the critical questions, values, and just not competence here in what we're dealing with. And Judge Jones said the same. And so I don't want to dwell on this any longer other than tell you, for me, this is the threshold issue. The issue of race is the threshold issue. I have to be convinced in my mind that Judge Roberts comes to this critical job as the head of the 3rd branch of our government with a clear understanding of what we must do in this country still to deal with the issues of race and justice for so many minorities in this country. Thank you all on this panel. Thank you, Mr. Chairman.
Thank you very much, Senator Durbin. Thank you very much.
Mr. Chairman, with your permission, if I could just make one quick clarification.
Go ahead.
We've been talking, thank you very much. We've been talking about redemption, and I don't think that John Roberts needs to be redeemed in any sense whatsoever, but to the extent one claims that his position on the Voting Rights Act was somehow wrong prior to the effects test, let's take a look at the facts. After the effects test was implemented, what did Judge Roberts do? He argued Chisholm versus Romer. He argued the Houston Lawyers Association. He argued for an extension of the effects test to state judicial elections. If he redeemed himself at all, he clearly did it right there. So we have facts here. This is not speculative. In terms of looking at his heart, if it's conflated with what he's done on the court, and I don't know that you can necessarily discern that, we have absolute evidence of what he felt about enforcement of the effects test.
Thank you, Commissioner. Senator Sessions wants a minute recognition before we break for a very abbreviated lunch.
Thank you, Mr. Chairman. I would just like to add, I've been listening to some of this as I could. I would just like to add that we've heard explanations from Judge Roberts on each one of the memorandums he wrote, each one of the situations that he was called to express an opinion on, such as the effects test. His ruling was absolutely consistent with the Supreme Court ruling of the United States at that time. So all I would say is I think it's unfair to suggest that he has a record that indicates that he was somehow wrong on civil rights at that time. Yes, he opposed quotas. Yes, he supported the extension of the Voting Rights Act completely, but he did not favor its alteration to overrule the Supreme Court opinion. So I would just, for the record, like to say I believe his record does show affirmatively that he is committed to equal justice under law, which is what he's called upon to do. Thank you very
much, Senator Sessions. Senator Kennedy, you have a unanimous consent request?
Consent that the NAACP Legal Defense Education Fund prepared some important testimony to be made a part of the record.
Without objection, it will be made a part of the record. Thank you all very much. We have so many witnesses, we're going to have an abbreviated, not a lunch hour, but a lunch half hour. We'll resume at 2 o'clock.
After that panel, Senator Sessions and several of the witnesses